A woman sits in a Boston clinic with a family history written in funerals. She wants a second laboratory to read 2 genes in her blood. The second laboratory refuses, not because the science is hard, because the genes have owners. Those owners sit in Salt Lake City. Myriad Genetics holds United States patents on BRCA1 and BRCA2. The patents cover the isolated sequences. They cover testing. In practice, they cover the doorway. A hospital that sequences the same stretch of DNA can expect a cease-and-desist letter. A researcher who wants to hunt for a mutation the company missed can find the work legally fenced. The company's test costs thousands of dollars. Some insurers pay. Some patients wait. Some never come. This is 2010. This is the United States. This is not a metaphor. By the early 2010s, the United States Patent and Trademark Office has granted patents covering approximately 20% of the human genome, over 4,000 genes. Private corporations and researchers hold exclusive rights to isolate those sequences, to test them, and to research them. They do not own the physical DNA molecules inside a living person's body. They own a monopoly on the isolated sequence as a composition of matter, a legal toll booth on a biological fact. That distinction is precise. The power is not small. A gene is a description of nature. For 3 decades, American patent practice treats the description, once chemically lifted from the cell, as an invention. Isolation becomes authorship. Purification becomes creation. The map of the body acquires landlords. You inherit the letters. Someone else inherits the claim. You can carry a mutation that raises the risk of breast and ovarian cancer. You cannot, without permission or payment, have an independent lab confirm what those letters say. Examiners in Virginia treat a sequence copied from a chromosome as something made. The human genome is a shared text. Parts of it now have a price. How does an office that grants monopolies turn facts of biology into assets? Who collects the rent? Who pays it? In cash, in delay, in research that never ran.
The Hinge is 1980, and it has 2 doors. On one door, Congress writes the Bayh-Dole Act. Universities and small firms may patent inventions made with federal money. The old default, that publicly funded knowledge stayed in the public, begins to close. A campus laboratory can now become a licensor. A faculty sequence can become a royalty stream. The stated intention is translation. Get inventions out of drawers and into products. The outcome is a new hunger. Technology transfer offices open. On the other door, the Supreme Court decides Diamond versus Chakrabarty. Ananda Mohan Chakrabarty, a General Electric microbiologist, has engineered a bacterium that can break down crude oil. The patent office says nature is not patentable. The court, 5-4, disagrees. Chief Justice Warren Burger writes that the claim is not to a hitherto unknown natural phenomenon, but to a non-naturally occurring manufacture. The phrase that leaks into every later brief is older and wider. Anything under the sun that is made by man. Made. The patent office hears it as permission.
If a modified microbe is a manufacture, what about a molecule that did not exist in purified form until a technician cleaved it from a chromosome? Lawyers argue that isolated DNA is chemically distinct. Bonds have been broken. The sequence has been removed from its cellular clutter. It is a composition of matter, they say, not the gene as it lives in you. Examiners accept the argument. Through the 1980s and 1990s, claims issue on isolated genes, on complementary DNA, on methods of detecting mutations, on primers, on kits. The office does not hold a referendum on whether a fact of biology should be fenced. It applies statutes written for machines to molecules copied from bodies. The United States Patent and Trademark Office is pushed toward a user fee model. Filings pay the bills. Grants please filers. A rejection is extra work. An allowance is throughput. None of this requires a conspiracy. It requires incentives. Examiners face art units stuffed with biotechnology applications they cannot fully read as biologists and cannot fully refuse as clerks. In 1990, the Human Genome Project begins as a public effort to sequence the 3 billion base pairs of human DNA. In 1998, Craig Venter's Celera races the public consortium with machines and private capital. Both sides file. The public project dumps data into GenBank to keep sequences from being locked. Companies still claim isolated molecules and uses. Insight Genomics, Human Genome Sciences, and a cluster of universities stake out expressed sequence tags and full genes. A single disease pathway can sit under several owners. In 2001, the Patent Office publishes utility guidelines. A gene patent is supposed to recite a specific, substantial, credible use, not a fishing expedition. The reform trims the wildest applications. It does not end the practice. Isolation plus a stated function still issues. What most people miss is that the patent is not a trophy on a wall. It is a right to exclude. For 20 years from filing, the owner can stop others from making, using, selling, or importing the claimed composition. In genetics, using the composition can mean testing a patient. It can mean running a research assay. It can mean confirming a result that a family already fears. Laboratories begin to ask a new question before they ask a scientific one. Freedom to operate. Who owns this exon?
Who must be paid? Who will sue? University council freeze projects. Diagnostic companies design around claims or abandon the design. Journals still publish. Benches go quiet in the rooms where a patented sequence is the only door. In 2005, Kyle Jensen and Fiona Murray publish in Science a census of the landscape. They match patent claims to the National Center for Biotechnology Information Gene List. The share that falls under claim is the share that will later haunt clinics. The paper is not a manifesto. It is a map of fences. The United States treats isolation as alchemy. Lift it out, and it is yours. The contradiction from the clinic now has an origin. A woman cannot get a second opinion because an office in Virginia spent a generation saying that a copy of her chromosome, purified, is an invention. The copy is not new. The monopoly is.
Mary Claire King does not work for Myriad Genetics. In 1990, after a 16-year hunt, she reports that a breast cancer susceptibility gene sits on chromosome 17. She names the region. She does not yet have the sequence. The race that follows is a race to letters, and letters can be claimed. Mark Skolnick works at the University of Utah. He has something King does not: dense genealogies from the Mormon Church linked to cancer registries, a population that can turn a family story into a statistical machine. In 1991, with Nobel laureate Walter Gilbert and venture backing, he helps found Myriad Genetics. The company's ambition is not a paper, it is a franchise on risk. The University of Utah, the National Institute of Environmental Health Sciences, and Myriad push to sequence BRCA1. In 1994, they publish the gene. Patents follow. BRCA2 follows in 1995, in a crowded field that also includes a British team at the Institute of Cancer Research. Assignment documents move rights into a corporate vehicle. The isolated sequence, the primers, the methods of spotting mutations, each becomes a claim. In 1996, Myriad launches BRCA-analysis. The product is a test. The business is exclusivity.
Full sequencing of both genes is priced in the range of $3,000 to $4,000, a figure that later settles for many patients near $3,340 before add-on assays. Insurers negotiate. Uninsured women do arithmetic. Myriad's general counsel sends letters to laboratories that offer bra testing without a license, including academic labs at the University of Pennsylvania. Doctors who had run homebrew assays shut them down. The motive is written in the cap table, not in a villain's speech. A diagnostic monopoly pays for itself. Every sample that must come to Salt Lake City also comes with data. Variants of unknown significance pile up inside the company's walls. The more tests Myriad runs, the better it becomes at classifying mutations. Competitors, even if they could sequence, would lack the private encyclopedia. Patent law is the lock on the door. The database is the furniture inside. Patients become the other character. Lisbeth Seriani, a single mother and breast cancer survivor, is told her insurer will not cover the test at Myriad's price. Janae Gerard wants a second opinion after a positive result and cannot legally obtain one from an independent lab. Their names will later appear on a complaint.
For years, they are simply people standing in front of a booth that charges to read what their parents already gave them. Inside the patent office, no single examiner sets out to ration cancer care. The file wrapper shows a familiar dance: composition of matter, utility and diagnosis, novelty of the isolated molecule, allowance. The institution's motive is statutory interpretation plus throughput. Myriad's motive is a return on the race it won. King's motive was to find a gene. The market that grows between those motives does not ask her permission. Life or death decisions compress into billing codes. A woman chooses mastectomy with incomplete information because a second lab cannot look. A researcher shelves a study on a rare BRCA variant because counsel fears infringement. A hospital compliance officer, not a scientist, decides what medicine may be practiced. Myriad is not the only firm on the genome. It is the clearest. 2 genes, 1 company, a national bottleneck you can photograph.
May 12, 2009. The Association for Molecular Pathology, the American Civil Liberties Union, and the Public Patent Foundation file in the Southern District of New York. The defendants are Myriad Genetics and the United States Patent and Trademark Office. The plaintiffs include pathologists, geneticists, professional societies, and patients. Harry Oster, then at New York University, states he would offer BRCA testing if the patents did not block him. The legal theory is not that Myriad failed to invent a better assay. The theory is that the claims cover products of nature and abstract ideas, which Title 35 never allowed. 7 patents sit at the center, among them United States Patent 5.747282. The claims recite isolated DNA coding for BRCA1, isolated DNA with specified mutations, and methods of comparing a patient's sequence to a wild-type sequence. Myriad answers as a firm answers. It funded sequencing. It disclosed the gene. It built a laboratory that returns results. Isolation, it says, is a human act that creates a new molecule. Without exclusive rights, it argues, no company would have spent the capital. March 29, 2010. Judge Robert W.
Sweet grants summary judgment for the plaintiffs. Isolated DNA, he writes, is not markedly different from native DNA. The decision hits a sector that had treated the opposite as settled. Biotech counsel predict a swift reversal. The United States Court of Appeals for the Federal Circuit is the specialized court that hears patent appeals, and gene patents have lived comfortably in its doctrine. The Department of Justice does something unusual. In 2010, it files a brief that splits from the Patent Office's long practice. Isolated genomic DNA should not be eligible, the government says. Complementary DNA, a synthetic molecule with the intervening sequences removed, should be. The Solicitor General's office has just told the country's patent tribunal that 30 years of grants rest on a mistake about genomic DNA. July 29, 2011. A 3-judge Federal Circuit panel divides. Judge Alan Lowry writes that isolated DNA is a distinct chemical with covalent bonds at its ends broken. Judge Kimberly Moore concurs in the result with her own chemical emphasis. Judge William Bryson dissents in part. He warns that the majority blesses a monopoly on a sequence nature wrote.
Composition claims largely survive. Some method claims, the ones that merely say compare and analyze, fall. The fence around the gene still stands. The Supreme Court, in March 2012, decides Mayo Collaborative Services versus Prometheus Laboratories. A method of adjusting drug dose by measuring a metabolite is not eligible. Laws of nature, applied with conventional steps, cannot be captured. The court vacates the Federal Circuit's Myriad decision and remands for another look in light of Mayo. August 16, 2012. The Federal Circuit looks again. It holds again. Isolated genomic DNA remains eligible in that court's eyes. Complementary DNA remains eligible. Lowry's chemistry still controls. The Marble Building is now the only remaining stop. April 15, 2015. Oral argument. The chamber is full. Justice Elena Kagan asks whether the first person who isolated and identified the liver could patent the liver. Justice Sonia Sotomayor talks about baking. She will patent a chocolate chip cookie, she says, not the salt, the flour, the eggs.
Christopher Hansen of the ACLU tells the justices that Myriad did not create the gene.
Gregory Castaneous, for the company, says the claims are to molecules that never existed in nature in isolated form. Justice Antonin Scalia admits he cannot follow the biochemistry and will not pretend. On May 14, 2013, Angelina Jolie publishes an essay in the New York Times describing her BRCA1 mutation and her choice of preventive surgery. The test she used sits inside the monopoly the court is still considering. Demand for testing spikes. The legal bottleneck is suddenly a household word. June 13, 2013. The opinion issues. Justice Clarence Thomas writes for a unanimous court. Isolated, naturally occurring DNA is not patent eligible. It is a product of nature. Myriad did not create or alter the genetic information. Complementary DNA is patent eligible because it is not naturally occurring. 9-0 on the genomic sequence. Scalia concurs in part, declining to join the molecular recitations he does not independently know. The morning after, counselors telephone patients who have been waiting for another lab. University protocols come out of drawers. Myriad Genetics and Gene by Gene announce BRCA tests within hours, at prices that undercut the old exclusive offering.
Other laboratories follow. Myriad's shares drop. The company files new infringement suits in Utah against competitors, now leaning on remaining claims. Executives talk about the variant database as the next moat. At the patent office, new guidance tells examiners that naturally occurring genomic sequences are not compositions the office will grant. Thousands of older claims enter a legal climate they were not written for. The court awards no damages to the women who paid monopoly prices. It does not reopen the studies that were never run. It does not audit a generation of allowances. It draws a line through composition claims and leaves the rest of the machine intact. The wound has a chemical name. Complementary DNA still qualifies. Method claims can be redrafted. Trade secrets need no filing. A private encyclopedia of variants, built during the years when every sample had to come to one company, does not vanish because a justice named a product of nature. The toll booth on 2 genes is kicked open. The road is not declared a commons. For nearly 2 decades before that June morning, American diagnostic work on BRCA1 and BRCA2 ran through a single commercial checkpoint.
Second opinion testing was a legal risk. Comparative research was thinner than the science required. Women made irreversible surgical decisions on a single laboratory's call. Collaborators abroad, in offices that never loved the isolation doctrine, watched American colleagues hesitate. In 2015, the High Court of Australia, in Darcy versus Myriad Genetics, rejects patenting the isolated nucleic acid on its own reasoning. The statute still rewards whoever first claims a molecule that can be said to be made. The genome, as isolated letters, is no longer allowed to be owned. The knowledge about the genome remains a business. And then, everything that copies nature goes back to the same verb: made. On August 26, 2026, Singapore's Ministry of Law and the Intellectual Property Office of Singapore opened a public consultation on overhauling the country's intellectual property regime for the artificial intelligence era. The paper is not about breast cancer genes. It is about the same species of choice, whether a legal system will let private claims close around a shared substrate of knowledge, this time of data, models, and generated work. The American years of gene patents remain the extreme case of what that choice can look like when the substrate is the body. A patent is a bargain. Disclose a made thing, and the state will let you exclude others for a term. The bargain fails when the thing was not made, only found, copied, purified, claimed. Courts can repair the failure late and narrowly after the rent has already been collected. Patients pay in the interval. Researchers pay in the interval. The office that issues the claims is not designed to feel either payment. The principle is colder than a morality play. Institutions follow the verbs in their statutes. If the verb is made, lawyers will stretch isolation until it sounds like manufacture. If the incentive is a user fee, the office will prefer an allowance to a philosophy. If the prize is a 20-year right to exclude, a company will race not only to know a gene, but to own the isolated copy. Intention can be innovation. Outcome can be a checkpoint on care. The channel of power here is not a secret society. It is a filing, a claim chart, a cease and desist on letterhead, a billing code that will not pay a second lab. Ordinary paper, stacked high enough, can ration a body. The 2013 line did not end the conversion of biology into asset. It moved the conversion. Complementary DNA, methods, software that interprets variants, databases that never publish, contracts that route samples. Each is a quieter fence. Each can be lawful. Each can still decide who may know. Artificial intelligence now trains on texts, images, genomes, and the recorded work of the dead. Companies argue that the training is transformative. Rights holders argue that the training is a taking. Legislatures draft consultations. The fight is new in its machines and old in its structure. Someone will claim a layer of the world that everyone else must use.
The models will not ask whether a sequence is a fact. They will ingest it. The firms that control the ingest will argue they have made something. The argument will sound familiar to anyone who watched a copy treated as a manufacture. The genome was supposed to be a commons of fact. For a generation, pieces of it were a portfolio. The correction arrived from a bench, not from the office that created the market. Correction is not the same as restitution. Picture a laboratory freezer. Inside, blood. Inside the blood, letters no company authored. For years, the letters could not be read without a license. The license is gone for those isolated sequences. The habit of fencing the map is not. A child born in 2014 enters a world where those 2 cancer genes are no longer a private checkpoint. She also enters a world where biological information still travels through companies, clouds, and licenses her parents never see. The court moved a fence. It did not abolish the instinct to build one. When the next map of life is written in code instead of base pairs, who will be allowed to read it without paying a landlord?